I will start with a few very, very brief comments of my own, and then we will get to the panelists. My own reflections on the last 2 days, I think, are characterized by the words intense and rich in regard to the discussions that have taken place in this room. And certainly, it's not our intention to summarize all of the important thoughts and insights and exchanges and arguments that have taken place, but rather to point the way forward in terms of looking into the future and what is necessary in deepening the legacy of the ICTY. So that's really our mandate before you this afternoon. Two other impressions. One, certainly, completion strategy, residual mechanism, functions and location of residual mechanisms, archives, transcription, all of those terms are issues of enormous importance to many in the communities most affected by the crimes in the Western Balkans. They generate, and we have seen them here, we have seen intense feelings and strongly held views. And I believe that the organizational and institutional questions involved in establishing the residual mechanism and the working out of the completion strategy require understanding and knowledge of that reality, the reality of how intensely followed from the countries of the former Yugoslavia these issues are. And I think that's not a moral injunction or imperative, but rather, I think, the expression of what is, in my mind, a unique responsibility for an international tribunal located, in this instance, hundreds of miles from where the crimes occurred, conducting its business in language that is not native to the region, and is very, very different than a domestic court sitting here in The Hague or in Rotterdam. That is the obligation and responsibility to make its proceedings and its work meaningful to those communities looking for justice. My second thought is that I was very pleased to hear yesterday President Robinson's statement, and it may be a poor time to raise this at the end of a conference, but I was encouraged by President Robinson's statement yesterday about another conference that he was envisioning in regard to the international and institutional legacy of the ICTY. And as I think about that, I'm looking beyond the Balkans to where victims are facing mass slaughter of innocent civilians, the use of rape as a weapon of war, be it in eastern Congo or Darfur, or in Gaza, or in Afghanistan. My point here is there is a need for all of us to think beyond the immediate communities and immediate cases before the ICTY and reflect on the commonality of suffering and the experience of victimhood that goes far beyond, unfortunately, the borders of the former Yugoslavia. And with that in mind, I look with great anticipation to future discussion. Now, I'm going to begin with a question for Tomislav Visnic. And I want to start with defense because it cannot be underscored enough that fair trials and credible trials require vigorous and effective defense. And I was struck by Mr. Wisniewski's comments yesterday in terms of some of the shortcomings that he, as a defense lawyer at the ICTY, had experienced, particularly in the early years. And the question that I have for you is, looking forward, what would you say to the UN Under-Secretary General for Legal Affairs about what the defense needs, both in a statute and in terms of institutional support? If we could start off with that point, I would be very grateful. Thank you.
Hvala.
Thank you. I will try to be quite precise in what I'm going to say. What we call the ICTY legacy encompasses, among other things, the case law. If case law is already being applied at trials in the region, then mechanisms have to be employed which will allow for the defense to work smoothly. And this applies mostly, and this is the message that I would like to send to the countries in the region, those who are responsible for these trials, and to the international community, that is, those elements of it who will be transferring that to the region, that this applies mostly to the rules of procedure before national courts, specifically if we have in mind the fact that the countries in the region are already in the transitional phase of amending their criminal procedure laws. This mostly has to do with the introduction of an investigation to be conducted by prosecutors themselves, which calls for the adoption of a direct investigation to be carried out by defense in the pretrial stage. Plus, mechanisms need to be introduced which will allow the defense to have direct access to state organs and to be able to send direct requests for assistance to state authorities. I'm primarily referring to the collection of documentation and information other than that which is already covered by the laws governing information of public interest in various states. This also applies to the obligation on the part of the state authorities to cooperate directly with defense teams on any other requests that they may have. Unlike the public prosecutor, in respect of whom there is the obligation provided for by the law, in the region there do not exist any mechanisms which would allow the adequate rights on the part of the defense counsel to a fair trial. Rule 54 of the rules of evidence and procedure, which has been invoked before the ICTY frequently, could be an adequate guidance in the resolution of these problems, especially if we know, and this is something we've heard frequently today and yesterday, if there are cases which are being conducted in more than one country in the region. If countries in the region are in the process of cooperating in terms of exchanging information for prosecutors' offices, they will have to envisage the fact that such a solution will have to be provided for the defense as well. This takes me to another topic related to the legacy, which is the ICTY archives. The ICTY archives have to be made accessible to the defense teams appearing before national courts. The opposite mechanisms have to be set up by the residual mechanism. The adequate mechanisms must provide not only for the documentation, which is part of the case file, but also the documentation which is extraneous to trials but is contained within the ICTY archives. Of course, while minding all the security measures. And finally,
interrupt just for one question here. We have 3 ministers of justice or representatives of justice ministries with us. I'm curious how you see that issue of access by defense teams to the archive files. If any of our Justice Ministry panelists care to say a word about that, I think it would be interesting. Please.
Thank you. One of the achievements of the ICTY is most definitely a fair trial. We have not heard so far mention of any trial either ongoing or already completed before the ICTY, which had not had or been given access to all the relevant documentation and been given assistance in the investigating stage on the side of the defense. So on the issue of the ICTY archives, I don't think that there is any other possibility than to allow access to the archives. It is not only the access to the documents that are readily available right now that is at stake here. Colleague Wisniewicz has raised the issue of accessibility of documents which are not accessible to defense teams right now. I don't see why the issue of accessibility to the ICTY archives should be raised as a question at all.
Hear that. And let me direct, if I may, a question to our 2 other Justice Ministry panelists. And that has to do with the challenges you face in both Zagreb and Belgrade in building understanding and support politically for the work of the Tribunal here in The Hague, but also for war crimes trials in your national courts, which I think we all agree on the basis of the discussion over the last few days is really an essential piece of the ICTY's legacy. In a word, what are you doing to address the challenges your governments face among the public at large and going against the tide, if required, in building support for proceedings domestically and internationally? Thank you.
Can I take precedence as a lady colleague?
Thank you very much for giving me the floor. I'm a national of a country which the International Court of Justice found to be responsible for failing to prevent the genocide in Srebrenica. But I'm also a national of the country whose president made a public apology to the victims of Srebrenica, which I think is an ethical